Very good afternoon, friends. I extend a very warm and hearty welcome to all the participants and learned speakers to this 77th webinar on data protection legal development. And the important is what corporate needs to know. Being organized by corporate professional jointly with Pavan Duggal Associates as a part of its knowledge sharing initiative. Amar bhai, during this COVID period, we started when the first wave came, and 28th April, we organized first webinar, and since then, every Friday we are organizing 4 to 6, and this is our 77th webinar. So without any break, we are doing this knowledge sharing part to the corporate. Our very special thanks and very warm welcome to our chief guest, Dr. Amar Patnaik, and our guest of honor, Mr. Rakesh Maheshwari, who despite of their hectic schedule, have joined us today to enlighten us on the proposed new law on data protection in India. Friends, data is power, and the new oil which has the potential to unleash the true power of an economy. It is the new resource that is vital for the internet economy, supporting innovation and building new age businesses. By use of data analytics and artificial intelligence technology, powerful insights are being generated to build new and innovative products and services. As you are aware that if you are getting something free, that means you are the product. That is the work which is happening. However, rapid commercial use of personal data raise serious concern with respect to misuse of sensitive and critical personal data, giving rise to the requirement of formulation robust data protection law. This law is equally important for the planned development of our economy as well as national security. So protection is one part, but usability is another part which we'll discuss today. The objective of webinar is to discuss and understand the legal landscape concerning data protection in India and also about the Data Protection Bill 2019, as well as the report on the Joint Parliamentary Committee, on which our chief guest was also a member. In addition, we have wished to discuss the various strategies and corporate need to adopt to protect their data under the prevailing laws, including the Information Technology Act 2000. Before I invite our chief guest and guest of honor to deliver the address, it is my privilege to introduce our chief guest, Dr. Amar Patnaik. He is a member of parliament from Odisha in Rajya Sabha, General Secretary of Biju Janata Dal Parliamentary Party Office. In Upper House, he heads the IT wing of and also the spokesperson of BJT. He is a member of Parliament Standing Committee on Finance, member of Subordinate Legislative Rajya Sabha. He is also member of JPC on Personal Data Protection 2019. Before becoming an MP, Dr. Patnaik was a career bureaucrat as an Indian Audit and Account Services Officer. He was instrumental in detecting fraud in Bihar, the Fodder scam, and Assam, the Letter of Credit scam in 1990. He was also associated with the United Nations and World Bank of the Global External Audit Assignment. He was also team leader of India's external audit mission to many countries. Interestingly, Dr. Amar Patnaik is BSc, MBA, LLB, Masters in Public Management, PhD, educated in St. Stephen College, Delhi University, Xavier Institute of Management, Bhubaneswar, Lee Kuan Yew School of Public Policy, Singapore, and John F. Kennedy College of School of Government, Harvard, and Xavier University, Odisha. He has wide experience and knowledge. He often writes an issue relating to economics, finance, technology, data, and environment, and he has authored the book Institutional Changes and Power Symmetry in Context of Rural India. It is indeed an honor to us to have with him with us. Please join me to extending him a very warm welcome to you. And interestingly, Amar Patnaik and we were together in Jubilee Hall. We were old friends. And Mr. Pavan Duggal and Mr. Patnaik, they were the college mate. So I think so many Delhi University people are participating in this. So welcome Amar Bhai for this program and thanks for accepting our invitation. Then we have Mr. Rakesh Mishra, he will join us shortly. He's currently Senior Director, Group Coordinator, Cyberlaw and Security at Ministry of Electronics and Information Technology. He has been with the Ministry of Electronics and Information Technology since '87 and having experience of more than 34 years. Mr. Maheshwari did BTech in Electronics and Communication from the prestigious Delhi College of Engineering. He's also from Delhi University. He's also actively associated as a judge evaluating young law students participating in moot court proceedings on cyber law. He has been speaking on data protection bill in several forums, and a great pleasure to have with him today with us and present the government's current thinking on this subject. We welcome you, Mr. Maheshwari. Then we have our partner, Mr. Pavan Duggal, is the founder and owner of Pavan Duggal Associate, Head Artificial Intelligence Law Hub. He has been practicing as an advocate Supreme Court, and over 2 decades he has made an immense impact in field of cyber law and law relating to e-commerce. He is the founder and chairman of International Commission of Cyber Security Law. He has been acknowledged as one of the top 4 cyber lawyers around the world. It's a proud moment, Pavan Bhai. He has spoken at over 2,000 conference, seminar and workshop and lectured immensely in the selected law college. As a writer, he has made his mark with 154 books on various aspects of the law. He has been contributing continuously weekly column titled Brief Cases in Economic Times for almost a decade. Welcome, Pavan Bhai, for this program. Ravi Prakash is an associate advocate and associate partner in corporate profession. He is a research-oriented professional, has extensive first-hand experience over 6 years in corporate and security law, representing many prestigious clients before SAT, SEBI, and other forum. He has been the vast knowledge or to draw upon these matters spanning across securities violations, shareholder dispute, white-collar crimes, and other contentious issues. We welcome you, Ravi, for this program. Friends, these are our speaker, practitioner, regulator, and the lawmaker. And he is not only the lawmaker, but he is the expert in that area. So today we will definitely get benefited, and we will get it, the in and outs of this particular data protection law, which we think it's a normal part. The program structure will be this. After my introduction, our chief guest will speak, then our guest of honor will speak, and then Pavan Duggal and Ravi will speak, and then we will have a question answer. Mr. Patnaik has another meeting, so after this his speech, he may go, and we have requested him at the most whatever best he can stay, and all the suggestion and things we will send it to him and the regulator also. So friends, this is our today's structure. Anybody has any questions, they can write down, and we will after the presentation we will ask the experts. The program name is the What Corporate Should Know. Today what is happening, that we are using data. Yesterday my wife took a photograph for one jewelry, and immediately the Malabar ad has come. I went to one particular, I think some chotha function of somebody died, and there was a speaker singing some bhajan. On my YouTube, reflected his name on the top. So there is something inside happening. In iPhone, you can track your all movements. You can see where you have gone without noticing this. So the point is, you are watched every time. Aadhaar, various other things has come. So today is the time to understand, because Amar Patnaik has represented in the JPC, and he was protecting the right of the citizen of India. And we want to understand from him this particular law and what JPC has done, and whatever his point of view, that how this particular thing can be protected by the misuse. Though law you can make, but everybody should know. And especially corporate should know that what they are doing, either they are taking a data, which they are not realizing that if you are taking data, it is free, but you are violating somebody's privacy. So it is a violation, and the penalty is also very high. So over to you, Amar Bhai, for your deliberation to help.
Thank you so much. Thank you so much, Pawan, and thank you to the other stalwarts here. I don't admit of any expertise on this subject, except the fact that I understand the importance of data. I do understand the importance of IT. I have, during my career as an auditor in the CAG's organization, had audited the IT systems of the United Nations at New York. So there is a fair amount of understanding. And then, of course, I invested, along with my colleagues, about 1.5 years in going clause by clause of the personal data protection bill that had been introduced by government in December 2019. I will just, since this is a huge subject, this is a new subject, but I would gather all that importance in one sentence by saying that to me, this appears to be one of the most important legislations that independent India is going to have in terms of protecting the privacy of citizens. More so after the Puttaswamy judgment of both the judgments which happened in quick succession, which declared the personal, the informational privacy of a citizen, whom the bill calls as the data principle, as a fundamental right. Now, this actually takes the entire discussion and the entire gamut or the interpretation of the bill, any bill that comes, because today I read in the newspaper that the government is probably thinking of introducing a new bill, but any bill that comes and gets finally passed by the Parliament will have to, will be tested against the principles laid down by the Puttaswamy judgments of the Honorable Supreme Court. And those principles have been very well laid down, of course, borrowing heavily from the only other widespread legislation available, which is the European Union's GDPR, the General Data Protection Regime regulations. So I think that while doing any kind of, because this is a new act, any kind of implementation, and if there are bound to be areas where there would be confusion, there would be overlaps, there will be overlaps between sectoral regulators like the TRAI, like the RBI, like the Competition Commission, like the it could be a state government's independent organization, it could be an autonomous body like the CAG, it could be the Chief Election Commissioner. That is, so to that extent, I have written in my articles that this is a fourth generation, democracy institution, because it also brings under its ambit the regulators. Anybody who collects data is called a data fiduciary. And by choosing the word fiduciary, as we understand law, there is a trust relationship between the person who is sharing the data, from whom the data is being collected, and the person who is storing it or keeping it. And then there is a person who could actually be any different from the person who has collected, who is processing it. So the entire structure has been laid down in this bill in the form of, by using these terms like data principle, data fiduciary, a consent manager who manages the consent of the data principles of the citizens who give consent to XYZ. Data fiduciary is to manage the data or to process whatever. I'll come to the details, but suffice is to say that this is one of the most significant legislations that independent India is going to see in terms of individuals' right to life, which subsumes now, as per the interpretation of the Honorable Supreme Court, the informational privacy, and also the fact that the way data is used both within the country and across the countries or beyond the boundaries, how the data would be handled for those who are coming into the country with data, and for India sending its own data to an outside jurisdiction. So this law, to that extent, is all encompassing. It's an umbrella legislation over sectoral regulators. You must realize, this is all of you are professionals, that the current form of the law suggests that every sectoral regulator will have a memorandum of understanding with the Data Protection Authority, which is going to be the supreme body at the central level, regulating and implementing this particular bill. These memorandums of understandings will have to be worked out. This is not going to be easy, but because of the fact that this has been given a fundamental right status, I would assume, this question has been asked to me before, I would assume that if there was a disruption in the balance between promotion of individual privacy and digital economy, the balance is to be tilted in favor of individual privacy, since the court has declared it as a fundamental right. This is not there in any other jurisdiction, and therefore it makes it different. So any law, even if it comes out later, will be tested in the courts, in the constitutional courts, against this basic principle. Of course, there are sub-principles like a principle of data, purpose limitation, data, storage limitation, collection limitation. I will explain to you what are these terms, but this is the basic principle. So you cannot, I guess, come and say that no, my business is affected. If I do this, I cannot keep on taking consent. I cannot take consent from him. I don't want to inform him anything. My secrecy will be gone and all. I think in these, the courts have already decided, even in a non-electronic data format. Incidentally, all those people who are handling data in a non-electronic format are also covered under this act. And this is the first act, unlike the IT Act, which includes the government. The central, the state, the local self-governments, the third tier of government, all government is included because government collects data. Therefore, it is the single largest data fiduciary. It is a bigger data fiduciary than even the big tech companies standing on their own. But the important thing is that even during normal times, the constitutional courts have upheld the fundamental rights over anything else. And since this is a fundamental right, I think the courts would take that view. Having said that, all this will get tested once the new act finally gets passed in the parliament and the rules and regulations start getting framed. What the act does in brief is that earlier you could collect data from an individual, and the individual could share data freely out of his own volition, and not know what the person who has collected the data from him doing with it, whether it is going to cause him any harm or whether it is going to cause him any benefit. Now, this particular aspect first came up for discussion. I'm making it very simple without using any kind of jargon. First came up for discussion during the Aadhaar judgment, which I was talking about as the Puttaswamy judgment, where it was decided that the personal information of an individual is as important as his life. Just as Article 21 enjoins the Constitution to protect. The Honorable Court itself understood, as Pavanji said, that data is the new oil. We just keep on keep on only protecting the individual rights of life through information privacy.
Dr. Amar, please check your connection. I have. I think there is some connection issue, so he's rejoining.
Sorry, I think we got disconnected. There were some slides which came up from nowhere. So I was just suggesting that we all our business processes, all our government functions, all our transactions now have to be cognizant of this fact that this particular aspect of the citizen or data principle, the person who is sharing data, has to be protected. What would be the nature of this protection? This is laid out in this law because, again, the Puttaswamy judgment said that you can't just leave it like that. It has to be backed by law, and then it has to be having certain principles, and those principles were also laid down. And while doing that, this is again something which people probably forget, that it also says, like any fundamental right, any fundamental right of freedom of expression, Article 19, there are reasonable restrictions. Reasonable restrictions have also been brought into this particular act, and that is by way of a section which is called Section 35, as to what, where those exceptions apply. There is a debate whether those exceptions would only be available to the government or should also be available to private parties. There is nothing about private parties as well. These are debates and discussions. Getting into minor details I'll not get into, but I will say that the Supreme Court talked about certain key principles, and those principles are very important. That there will be a purpose first, that you have to get the consent of the person. You have to tell him for what purpose you are collecting the data, and what is the purpose for which you are going to use it. And then he gives his consent. This is to that extent an informed consent that is specified. Whether the person exercises informed consent or not is a different matter. Whether Indians can do it, given the kind of literacy that you have in rural areas, that's a different matter again. But the law specifies it. And after that, the amount, once the purpose has been served, the data principle is at liberty to say that I don't want that data to be retained by the consent manager or the data fiduciary anymore. The data should be removed from there. Right to be forgotten. There are two rights which have been given: right to eraser, and right to be forgotten. Right to eraser is a smaller right in the sense you can erase it from the data fiduciaries or concerned data fiduciaries systems. Say that your purpose has been achieved. I don't want my data to be there. But right to be forgotten is a much broader right, which means that I want to be forgotten from the entire internet. Whether that's feasible or not is a different matter, but it is possible. And this also right has been given to the data principle. The Act itself, in its 8 or 9 chapters, talks about the right of the right of the data principles, the obligations of the data fiduciaries, the data privacy by design, the exemptions, the offenses, the penalties, the structure of how the grievances would be addressed, the complaint handling mechanism, everything is made out in the Act. So this important thing is purpose limitation, data minimization. If you want to process a person's, let us say, passport, data relating to his passport, you may not probably require his income. So that is called data minimization. You only collect that much data which is necessary. So you do not collect unnecessary data from the data principle. There is also something called storage limitation. So for how long you want to store his data, that also would be specified. So that puts basically, in a sense, there's something called accuracy, there is integrity and confidentiality. So all this is a part of the principles that the Supreme Court has laid down, and it is borrowed also from the EU GDPR, that says that the new law, or even if when there is no law, if any action is to be evaluated by the constitutional courts later, they will follow these principles to evaluate if there is a violation by a data fiduciary. Now, the question of why are we doing all this is because of the fact that we are giving a right to this data principle, the citizen, that if in case we know what is the kind of leakages of data that takes place, the breaches of privacy of citizens that takes place at various levels, what this law will now do would that the companies or corporations or platforms, intermediaries who are handling data, all data fiduciaries, will have to invest much more to ensure that there is security and integrity of the data that has been collected under the meaning of this Act. And unless they do that, the penalties for breach, and if there is a harm which has been caused to the data principle and can be linked to this particular breach, then the penalties are quite huge. For different kind of violations by the data fiduciary, the levels of penalty are different. And there is a very significant thing in this Act that there is also penalty for a government department in case there is a breach of data from the government setup. The most important thing about this particular bill, besides what I have said, is that there is a data protection authority which is going to be members and which is supposed to independently regulate the implementation of this Act. There have been questions which have been raised about the independence, the expertise, the competence, the functionality of this data protection authority. I myself have given a dissent note on various aspects, including this. So one more point which I thought is important about this Act is privacy by design, which basically means that any person who is designing, who is making his data, who is collecting data, he has to re-engineer his processes, both manual and electronic, to ensure that data privacy is retained, the privacy of the data principle is protected. Now, when I say, you might have this question as to what is this privacy? If you have data which can identify the data with a person, then that identification itself so the citizen's privacy is compromised. If you can anonymize that data using various encryption tools, and by that process that nobody can identify the individual with the data unless it is de-encrypted, then there is no problem of privacy. So once encrypted data is there, then it goes into the realm of non-personal data. There are two kinds of data, personal data and non-personal data. Here we are talking about personal data protection, but in the bill which we have proposed in the JPC to the Parliament now is a common data protection bill, Data Protection Act, and not just the personal data protection, because we believe that the personal data and non-personal data cannot be put in tight jackets or silos, and they can have separate authorities because they could probably give rise to turf wars, number one. And number two, at what stage the re-identification by a rogue element happens, that also would be difficult. And therefore, we made a single bill, just like the EU GDPR has only European Union data protection regulation. It doesn't have two separate regulations. The shape in which the current bill has now come, however, if you look at the statement of object, it says that and the Supreme Court does say that data has to be promoted for digital economy as well. Data has to be used for digital economy. But if you take these safeguards, then you can use that data for digital economy. And then the definition of non-personal data is anything which is not personal data is non-personal. That is what this Personal Data Protection Committee the BN Krishna Committee has suggested. And that is what also even the Krish Gopalakrishnan Committee has taken. So the non-personal data has a light touch regulation. I would, since the entire regulation related to non-personal data has not yet come, but there is a provision in the current form of the bill that has been reintroduced in the Parliament. I would think that there should be the light touch regulation, because there the concern is promotion of digital economy to give benefits to the same data principles from whom the data has been collected. Many of these data could probably have been generated by systems not linked or identifiable with the data principle at all, in which case it can be used for either the individual beneficiaries, but then again, the data over there has been treated as an asset, and therefore individual will having data has this as an asset. There is something called community data, what in economics you would have probably common property resources. And therefore, that has also been dealt with. How the regulations and rules will look for non-personal data is not yet known. Government will be working on the report of the Krish Gopalakrishnan second report, revised report. But all that I can probably end by saying is that we are in a different regime now, different regime of privacy, data, and digital economy. The balance is very difficult to attain. But my guess, as I said, again, I'm reiterating at the cost of repetition, is the fact that if there is a conflict, then the courts will interpret it to the data principles right over any other right of a corporate or anybody else, because that has been treated as a fundamental right. Had it been only a right, only guaranteed by an act, then it would have been very different. So your design of processing of data, individuals' data, your design of IT systems and security systems, your design of privacy principles within the organization itself, even a hardware manufacturer would need to have a privacy by design in principle. And that's a chapter, I think, I think chapter 4 or 5, chapter 5, I think, in the data protection PDP bill. So that would actually engender a culture of regulated data use, but not at the cost of protecting the individual's right to privacy, but also not at the cost of completely doing away or giving up innovation, giving up use of data for promotion of economic benefits. Both the things will have to go on, but one has to be aware of this constraining factor, which is that individual's right to information privacy. So I think in brief, I would say that this is the culture that one has to live with. Just as the corporates would be facing a problem, just as the startups would be probably facing a problem because of the highest compliance costs. But I can tell you this much, that the bill that you are saying and the bill that you would probably see from the JPC has a carve out for startups. The bill itself talks about regulatory sandboxes. So we have put in also provision of innovation sandboxes. So I think overall, the JPC has tried to give a balanced approach, but it is not going to be business as usual. It's not going to be business as usual. And that is the most important thing. If you are implementing a new regime, there will always be costs. But these costs will give benefits later. Imagine this law having been implemented since in 2018 in the European Union. It says that if cross-border data flow would happen only when the other jurisdictions' data regime is necessary and is sufficient, is adequate and sufficient. Now, if the regulator finds that it is not safe for the data of Indians to go to, let's say, X country outside India, then the cross-border data flow will not take place. So I am also of the view, which I've expressed at several places, that a time will come when there has to be an international treaty or international organization in the lines of WTO, or it comes within the WTO itself, where people will be having agreements for cross-border data flow in different areas. If the confidence is high, the trust is high, if the measures to protect individuals' privacy, while at the same time the level of encryption or that is the metadata that is generated, is it safe that it is not somebody can once again re-identify that data with the principal? If that trust is there, then between two countries where FTAs could be there, free trade agreements, which would have a higher level of sharing of data, cross-border data flow than a global level. That is also possible. How it would happen, I do not know, but I can tell you that the G7 would definitely be discussing this over a period of next few years, just as suddenly they woke up to the fact that the big tech have to be charged a minimum corporate tax of 15%, which was not there earlier. Thank you.
Thank you very much, Dr. Amar Patnaik. You have not given this presentation as a legislator, but you have given a presentation like an expert of this law. I think Pavan Duggal will agree with me that the way he has given the all aspects relating to right to erase, right to forgotten, and data protection, the data personal, non-personal data, everything he has covered, and the privacy by design. So many things he has covered, which is a need of this hour. No doubt, when we see the pollution law, same issue is coming. You want industrialization also, but simultaneously you have to protect the environment also. Same here also, you require data to provide the benefit to the poor, providing subsidiary, identify who is the below poverty line, who are others. For that you require a personal data, but simultaneously the same personal data you can misutilize also. So the fear is always there, and that's why when the Aadhaar issue came and the people were opposing that Aadhaar, that you will manipulate this, these are the things. Dr. Amar, because you have to go, I'm just asking one question from you, and I'll request Pavan Duggal also, he can raise one question, which is...
yeah, please ask questions. A little bit change in your structure of the show today, but please bear with me.
Mr. Maheshwari has also joined. Mr. Maheshwari, welcome to you, sir. When JPC came, when this particular law is referred to JPC, what was the main concern of because to see the law and review the law is a good exercise. But in this particular thing, data protection, there was so much hue and cry. So what was the main point which parliamentarian was raising? And you have correctly ratified that point, or you have correctly corrected that point of the government view, Dr. Amar.
You are asking this question to me?
Yes.
Yeah, so the concern of the various people who have deposed before the committee, actually there have been so widespread consultation. I think very few committees would have had so many sittings and with so many different people with different purposes or different business purposes who would have been called to the committee. So almost everybody had been called, all the big tech firms, all the telephone operators. So the academics, the e-commerce platforms, the government departments, all these people had been invited, and they deposed before the committee. But the biggest concern which has been expressed in the entire act is, if I may say, number one is, I think, the exemption clause 35 given to government. So the exemption is not limited to only that section 35. It is in the other sections as well, where the government, in order to implement public policy, has been exempted to seek consent before processing data. Now the point is, I'm giving a very fair view that Article 19(2) makes reasonable restrictions, and therefore that has to also be there in the Act. However, it should be as narrow as possible, because the government itself is the biggest data fiduciary. And whenever in India we have had, even till now so far, any violation of fundamental rights and people go to the court of law, constitutional courts, it is against generally the government. It is not against private parties. So the government is the one which will be, and since this is a fundamental right, so it is most likely that the data principles will go to the courts for enforcement of this right against the government itself, which is the data fiduciary, in case there is a data breach. Therefore, the government exemption has to be there, national security, all these things has to be there, good relations in other countries. But when you have a subject like public order in that section 35, which is public order is number 2 in this in the list 2 of the 7th schedule of the Constitution, which is a state list, which is to be on which the states can legislate. Why should the center be legislating on public order? And therefore, my dissent note I had submitted is this, that we need to have state-level data protection authorities and not one large behemoth at the central level, calling itself as the Central Data Protection Authority of India or something, because it is not workable. Not workable even in action, even in operationalization, and even on the issue of center-state relations. Imagine a situation where a citizen complains before the Central Data Protection Authority that his data, which was collected by the collector of a district, or even in the worst case, the information, like we run a program in our CM's office, which is called as the More Sarkar. CM's office itself collects directly data from the people who go to police stations to know their feedback about the government services. But suppose he makes later that data gets, let's say, revealed through not through a public disclosure, but by data leakage, there's a breach in security, then the citizen can complain against the CM's office and the Central Data Protection Authority will be taking a call on that. It is just not going to work out. That's what my dissent note has been, which is not there in the design of the bill. So this is one area which has been a concern. Exemptions have been a concern. The other portion is the non-personal data. Why should it become a part of the personal data, giving the impression that non-personal data will also follow the same rigor? But I think the committee members were very clear that it will not follow the same rigor. But since it has been included there, people have that impression. The another point, which is debatable, is the fact that any law which is passed in the parliament, amongst the MPs, amongst us all, becomes an act of the parliament, becomes the law. Now, for implementation of that law, is it not fair for government to assume that for implementation of that law, I do not need to collect this data again through the process of consent and whatever else? Because it has been passed by the parliament. That is the government's argument. But the committee members, many of us feel that it is probably the government should not be treated at a different pedestal. So this debate goes on. The defining thing, as I said, ultimately would be that the operationalization of this entire law. The operationalization currently, since it has been borrowed heavily from the EU GDPR, whose population sizes are very less, where manual data is very less, where the structures are very less, we have 3 layers of government or maybe 4 layers of government. Therefore, if at every stage, in all fairness, a data fiduciary while collecting data, he takes consent, while processing data, he takes consent, while erasing data, whatever he takes consent, then it is probably not workable. So these are the concerns which have been expressed by various members of parliament as well as other stakeholders. And I'm sure these are the issues which must be rankling Mr. Maheshwari and others.
Okay, thank you. I think Mr. Maheshwari will reply to this. Pawan, you have any questions to him because he has to go. That's why.
Dr. Patnaik, kind of a new compliance mindsets do corporate need to be prepared for? Because corporates are confused. Should they start working from the parameters of the PDP bill? Should they wait on? Would they be given any potential kind of a breathing space once a new law comes? Because from what's appearing, it's going to be a de facto, de novo, a new kind of an exercise that's going to be coming forward. What could be your 3 crucial advices to corporates as they are preparing for this new regime today? Thanks.
Thank you, Mr. Duggal, for this question. Currently, the way the bill has been designed, or when it was introduced, there are no transition clauses. There are transition clauses or sections. There are no parameters as to, let's say, the IBC, for example. It is being rolled out in phases. First is the corporate IBC, then cross-border IBC will soon be rolled out. So it is happening in phases. Last thing here in this law. But what the JPC has recommended is the need for having a transition clause. And this transition clause could actually be different for different people, a graded one. For the startups, it could probably be a little longer. And for the others, it could be a little less. The government will have to take a call on this. But even without waiting for any of this, I think the couple of things that I'll have to first do, the culture of privacy has to first come into all organizations. Now, secrecy and privacy are different. Secrecy, which the government stands by, is different. Privacy is of the citizen. Secrecy is of the government. And the secrecy of the government is ruptured through the RTI Act, or there is an instrument which ruptured that particular thing. But here it is the privacy of the citizen. Now, privacy of the citizen can come when every employee of the organization realizes that I have to respect the privacy of the data from my customer, from my subscriber, because the leakage can only happen at various levels of the employees only. So I think that culture has to come out in the organization. These meetings should keep on happening. The training should keep on happening between different layers of government who handle data, of the corporate organizations who handle data. But even more important, I think, lest it is subjected to different interpretation by managers and top leaders, there has to be a privacy policy of every organization. And that organization should stand by this privacy policy. One, privacy policy employees, privacy policy against the subscribers or customers. Now, these have to be now, I think this is a work which will have to be started immediately, I think, because whatever said and done, even if there is no law, the Supreme Court's judgment is the law of the land now. So privacy is now a fundamental thing. Therefore, I think without waiting for the law, the corporate organization should start working in having a privacy policy for its own employees so that their culture grows. And then another privacy policy as to how to handle data which is received from people or how to collect even data from subscribers and customers so that they're sensitized about it. They have to increase or they have to do audits and re-audits of their security policies, how the data that is collected, stored, and how the data is safely stored. The confidentiality and, as they say, the confidentiality, integrity, and availability of data, that the CIA of data, when you are handling that, the security also aspect has to be built in, so they must revisit that. The third thing is, I think a lot of compliance documents have to be created, even though electronic, which will have to be going to a subscriber or to a customer before you collect his data, stating the purpose for which the data is being collected. So I think unless this is done, currently the way we used to do it in a very informal manner will now requires formalization and therefore documentation, because the DPA can send inspectors to audit these policies of a corporate organization later. So it's better to work on it right from now. Another thing which I would also harp on is the fact that previously, if there is a data breach, and there's a harm caused to people or group of people, there is no penalty. Now the penalty is very stiff. It can actually, in monetary terms, it may be whatever stiff, but in reputational terms, it will be so much that it might lead to the death of the organization itself, particularly for companies handling data for AI purposes or for handling data for blockchain, use cases of blockchain. I think they will be held to account. And also for organizations like RBI or banks who are holding customers' data, if that is breached, then they will be held to account. They will actually face a very, very stiff penalty besides the reputational loss. So this is another thing in which I think they should work on.
I think the compliance of this practice is very important. Maheshti sir, you are the government, you have made this law. And Mr. Patnaik is the person who is approving this law through the parliament. Though it is, I don't know whether, but any question you think which is large interest of the country, and as a government, if you want to ask Dr. Patnaik, you can raise, which can be useful for everybody.
First of all, good afternoon, including Dr. Patnaik. In any case, I mean, it was our pleasure interacting with the members of the Joint Parliamentary Committee. I was there initially involved, but later on, because of, in fact, me being involved in IT Act, Cyberlaw's activities, and being the designated officer for 69A, I could not really later on participate in the meetings which were held. So, I mean, up to a point, I was in the connect, but beyond a point, I did get disconnected. But the way sir has explained, I mean, including the fine nuances of the bill, the present bill, the recommendations, as well as the expectations from the government, as well as the body corporate, has been very well conveyed, and it rightly captures the issues. And the fact also remains that this is an ever-evolving subject as of now, fast changing, and to that an extent, any bill, any act for that reason will remain probably something, I mean, which we will find that maybe we can do more, or we could have done more. So
Sub-optimized.
Yeah, sub-optimized. So this is something, I mean, where the agility of our ability to amend is important. I completely agree with you, sir, that when you are saying that a single monolithic data protection body, data protection authority, in fact, if you look at the examples of how others are doing, even in a small state like Germany, in a small country like Germany, I mean, so we find multiple data protection authorities. So we have to be pragmatic. We have to be, I mean, clear that the kind of onus as of today, which has been put on the data protection authority, is actually huge. So in order that it is able to work, I mean, with a good response time, with the right expectations of the people, because today we are finding lots of cases in the courts, particularly on right to be forgotten. And this is something which is the present IT Act does not really address at all. So it is basically left to the jurisprudence of the courts, or maybe there are few laws which do cover, in which cases the identity of the victim or the perpetrator even cannot be revealed. So in our view, in my view, personally, I do believe that the JPC has done a fantastic job of interacting, having so many meetings, and being able to bring consensus to a large extent. So I mean, ideally, we have worked in a very democratic manner, sir.
Right. Yes.
Having consensus,
the way the cooperation is there from the Ministry of IT all through these 2 years. Imagine a situation in the first wave when the entire country was having lockdown and there was limited, air travel. Members have sat down almost every week in the entire 2020-21 to go through every section. And the people of the ministry and law ministry as well, we would be telling them that, how does it happen if you change this wording, come out with a different paraphrasing of this section. They would come out with it in the next session. A lot of work has gone into it, and I think it was a great collaborative effort and a great exercise at knowing the subject. And I think if that can get disseminated, then I think India will be richer in having a culture of privacy, which is currently not there. You don't really value your data, but if you value your data as an asset, just as you are valuing your building, I have a feeling that once you start valuing, you start utilizing it more efficiently and more effectively. And that is what is going to happen in the country.
Yes, sir.
I think thank you very much, Amar Bhai, for participating in this program. I will request, as long as you can stay, you please, and if time permits, when we'll start question answer, you can rejoin it also. Thank you very much for your kind.
Thank you. Thank you so much. I have a webinar with secretaries of many states on this, the need for having a state level data protection authority.
Okay.
There are RTI activists, because the RTI Act, you must consider, since Pavan is here, Pavan means Pavan Duggal, that RTI is a Right to Information Act. If you are saying that the center's power to legislate on data protection bill, that is data, is the prerogative of the center, then how did the Right to Information Bill give the right to the states to have a separate RTI Act for the states? There is a central RTI Act, then the RTI for the states, they have RTI rules, and there is a state level information commission with members, and the appointment power of those members is completely with the state government. Everything is with the states. There are parallel structures. There is a national and there is a subnational structure. If you look at the Consumer Protection Act, and every citizen is a consumer, there are three levels of the regulation, regulatory authorities. One is national level, one is at the state level, another one is at the district level. Now, and here, there the consumer is consuming the product of those parties, let's say not data, but if you reverse the situation and say that this consumer is now actually giving data, and some of those products are coming from those people who are consuming this data, then by the same logic, it should actually be at the district level. A person in Malkangiri, if he is buying a television, LG television, and if he has a grouse, then he goes to the district court and files a complaint. Now, if his data is breached by the same LG company, he has to go to Delhi, and I don't know how he will do it, because there is no internet connectivity. He has to go over a tree to send an email. So this operationalization aspect has not been seen, and as Mr. Maheshwari said, I had been to Germany. They have 3 layers, and even many other countries, or even at the European Union itself, that's where I think we went wrong. European Unions, each country is like our state. And on top of the entire European Union's separate data regulators, there is an overall oversight board, data oversight board. Now, that is what we have really created in this act. The states will have to do it. Now, that is my argument in the dissent note, and that's the meeting at 6 o'clock webinar. But pleasure meeting you. Thank you so much. Learned a lot, and be in touch whenever we can discuss, because this is an evolving subject. This will continue to evolve, as I can foresee, because I have about 28 years of my career in the civil services, where I used to be auditing government departments, government schemes, government policies. I have done that all my life. I can tell you there will be several areas where there will be overlap, there will be confusion, there will be conflict and friction, in which case decision will be taken either by the Data Protection Authority or ultimately by the constitutional courts. Always this question will come, where is the balance? I give you the simplest example, with that I will end, that when a person goes to the block development officers applying for a house under the Prime Minister's Awas Yojana, then what happens is that there is a list who will get it immediately, then there is a list who will be considered as the waitlisted. Until the RTI, this was kept in the files only. After the RTI came, that is how it sought to bring transparency by saying that I have a right to know where is my name, because I want to get a house. Somebody who is junior to me should not have got it, or who is not eligible shouldn't have got it. But if you look at it from but then in the RTI Act, you can only ask for the copy of that note sheet of the file or whatever. But if you look at this Personal Data Protection Bill, someone can say that that particular information is a personal data, and therefore it cannot be revealed without asking the person consent, which is also provided in RTA 8F. So many such issues will come up, and I think they have to be resolved, and that will happen during the implementation of the provisions of the Act. And more seriously, when it will be involving the constitutional authorities. It has happened in Philippines, where the fight is between the Chief Election Commissioner of Philippines and the data protection regulator there. So, these are the issues which will arise. Thank you so much.
Thank you very much. Now I'll request Rakesh Maheshwari, who is Senior Director, Cyberlaw and E-Security, Ministry of Electronics and Information Technology, to share his thought on the subject.
So, good afternoon, Pavan Kumar ji. Good afternoon, Dr. Pavan Duggal ji. In fact, after such an interesting and I should say intense discussions as was led by Dr. Amar Patnaik, I am just trying to, give an analogy that maybe once we have reached the North Pole, any direction you take, it will be always in the South. So please do not expect much from me now. But then I will also like to give perspective of what the present law, the present provisions are there in the existing IT Act. To begin with, I'll like to just mention, of course, must have already been talked by Dr. Amar Patnaik in the beginning, that privacy, informational privacy has already been declared as a fundamental right. And therefore, the whole paradigm as to who the owner is, whether it is, let me just talk in the context of, let's say, big tech companies, who are collecting huge data, as to who the owner is. The ownership, in a way, there is a paradigm shift that the ownership is moving from the companies, from the data fiduciaries, from the data controllers to the data principal. So that's one big thing which has happened. From a business perspective, if the country does not have the strong privacy laws, in fact, we are losing on the business many a time because we do not have the adequate privacy laws available with us. And in the present circumstances, the way the IT Act was envisaged, I'll just come to that. I'll also like to mention, and which was mentioned by Dr. Amar Patnaik, that government itself is one of the largest data fiduciary. As of today, while of course government has to discharge the sovereign function of collecting the data and maybe providing the services to the citizen, to the residents of the country, many a time, government itself may not have the adequate security provisions to be able to maintain the right, I should say, degree of security, which for the data it has collected. And that's where the new data protection regime, after the Supreme Court has declared the fundamental right, makes it mandatory or makes an onus on the government also to ensure the privacy, to ensure the security, not privacy, security of this data in the hands of government. Now, beyond this point, I will now like to go. It's not that we are completely at zero. Definitely, a lot of water has flown. But in the present cyber laws, in the present IT Act, that means IT Act 2000 with its amended version of 2008, there are few provisions relating to security of personal data or relating to protection of privacy. And they are primarily conveyed in 3 sections, which is 43A, which deals with compensation for failure to protect data, section 72 of IT Act, which is for penalty for breach of confidentiality and privacy for the data which has been collected as part of the duties performed under the IT Act, and therefore predominantly applies to the certifying authorities, the CCA, the CERT-In, in fact, our own 69A functions which MIT carries out, but then per se, we don't really collect the personal data there. But then wherever government is collecting personal data under the Act, the provisions of Section 79, Section 72, in terms of the requirement of maintaining the confidentiality and privacy applies. And lastly, Section 72A, which talks of punishment for disclosure of information in breach of lawful contract. So if you have collected as a body corporate, if you have as an organization, if you have collected data, if you have agreed to certain terms and conditions, you need to honor them in terms of the confidentiality of such data. And in case there is a breach, it is actually a criminal penalty under Section 72A. Having said so, I will once again like to jump to Section 43A, which primarily and which provides the, I should say, an overarching the overarching scope for security of personal data, and in particular the security of sensitive personal data and information. Now, based on this particular section, the rules have also been framed in 2011, and they are sensitive personal data for sensitive personal data or information rules, so SPDI rules, that's how they are popularly known as. And why I'm talking of all this is, once again, one, that the new data protection regime is still in the bill stage, it has not become a law. And two, as and when it becomes a law, even then there is a grace period being available to all the organizations in the country, effectively 2 years of grace period, and till such time the new regime takes over, the old regime continues. And therefore it is important that while we understand the new regime, we should in any case comply with the existing regime. And therefore, understanding of SPDI rules 2011 is very, very important. Today, certain information like password, financial information, your health information, your medical information, your biometrics, your sexual status, your sexual preferences, they are considered as sensitive personal data. Of course, in the new bill, the scope of this sensitive personal data has been enlarged, but even today, a good number of parameters have already been declared as sensitive personal data or information. And for this sensitive personal data or information, if any body corporate is processing them, is collecting them, is processing them in some way, is maybe wanting to outsource to some third party organization, then they will have to follow certain security requirements in order to ensure security of this data, this information in their hands. And as I mentioned, today it applies to a body corporate. So per se, government today is not covered, but once the Honorable Supreme Court has already given the direction, the intent of everybody becoming accountable is already there, and that's how the bill was actually, the work on the bill was already started. So the present act, present rules not only cover the sensitive personal data to be collected by the body corporate or the persons located in India, but it also applies to any body corporate which may be functioning from anywhere in the world, but collects in a systemic way the data or information of any person located in India. So the present IT Act is extra jurisdiction, I mean, is extraterritorial, is the jurisdiction goes beyond India, and all those, I mean, it covers information of all the people who are there in India or who are likely to be impacted because of anything, because of any breach. And for any breach, if that happens, today also, I mean, you have computer emergency response team, which functions on a 24/7 basis, that you need to report such data breaches to cert in. So in future, when the Data Protection Authority comes up, maybe you will have to report from the security perspective to Computer Emergency Response Team, and from a data perspective to the DPA. So obligations may go up, but even today, you definitely need to report to Computer Emergency Response Team, and which looks into from the security perspective, the vulnerability perspective, and therefore issues advisories which are general in nature or which are very specific in nature. So depending upon how it takes. The present SPDI rules also talk of a consent framework. The present SPDI rules also talk of a data limitation framework. The present SPDI rules talk of the body corporates, the data fiduciary in the present context, to publish their privacy policy, which should incorporate all such items, which should include all these things. And the present SPDI rules also talk about your ability to know as to how your data is being used, and your ability to ask for erasure of that data from the concerned data fiduciary. The rules also mention that in case there is a breach, in fact, the Act mentions in case there is a breach, the onus is, of course, it does mention that the onus is on the individual to prove that there is a lawful gain or lawful loss, and the person therefore can ask for the compensation for which the adjudicatory framework also exists. All the state IT secretaries have been designated as the adjudicating officers, and compensation up to the extent of rupees 5 crores can be asked for. Now, in order to prove that you have been doing, you as body corporate have been doing the due diligence, the rules also mention that security standards or compliance to security standards, and a specific standard has also been mentioned, that the compliance to ISO, IEC, in fact, I should say ISO, IEC 27001 can be considered as a proof that you as the company, as the body corporate, were having or were doing the due diligence. So that is where compliance to such a standard will be able to give you some sort of an exemption. Otherwise, the onus is on you to prove that certain due diligences were taken by the body corporate to ensure the confidentiality, to ensure the security of the data in your hands. So this is where, of course, there are few provisions in the Aadhaar Act also, because that is the another act which has been published by this ministry in 2016, with amendments carried out in 2019. In fact, the whole Puttaswamy judgment, and later on the judgment in the Aadhaar case, the whole issue of privacy started with the Aadhaar only. So this is where I stop. I can take up few questions. As I mentioned, I was involved in the beginning with the data protection activities, but because of my other engagements, and then I should say another team in Ministry of Electronics and IT taking over on a full-time basis the activities relating to the new data protection bill and the JPC interaction with JPC, that I have moved out. So maybe I'm able to answer, maybe I'm not able to answer, but then given the fact that we have eminent personalities like Mr. Pavan Duggal ji, I'm sure, we should be able to respond to most of your queries.
Thank you very much, sir. Thank you. Your knowledge is indicative that you have a depth of this subject, and the concept related to this in our law, sir. There is only one thing, that you cannot read all laws, but thing is that you should be clear about the concept. So you are clear about the concept and the concept of your area, and what Mr. Patnaik has said, what you have said, it is a now evolving stage.
Yeah.
And the point is, in India, we are not understanding the value of privacy. We miscommunicate with privacy with secrecy, and that's why this issue is happening. Your liking and disliking is known to other person. He can manipulate if he is the powerful, and that data is the new oil which everybody knows. So today, if you see the valuation of all these new startups, they are not on the financial parameter, they are on the future parameter of how you can garner the information and how you can garner the subscribers and your uh, system. So thank you very much, sir. We will definitely take up now. There are two practitioners. One is the prominent in India. When there is a cyber law, then only one name comes in India. There's a Pavan Duggal. So I'll request Pavan, please speak about this subject and guide the corporate that what they should do.
So thank you very much. I am exiting. Good, thank you, Ji.
Can you come back again, sir?
I'll try.
Okay.
I'll try. Yeah, good. Thank you, Ji.
Thank you, Mr. Maheshwari.
Thank you, sir.
Thank you for your presence. Thank you, Pavan, distinguished friends, ladies and gentlemen. After these two power-packed presentations, the question that comes to my mind as a company is, where am I standing? What I'm really supposed to be doing? I had just prepared some slides. I thought I'll share that with you so that we can have a more idea of what I see on the horizon. So when, as a company, I'm talking about data protection, I'm concerned about a variety of aspects. The reason for this is one area that's now going to take a big chunk of my time, my energy, my resources as a company, as the corporate sector. Why is this possible? Primarily because every company is under attack. They're all sectors, all companies, and an academy, whether you are any other sector-specific company, you find that there are cybersecurity breaches. Now, why are these cybersecurity breaches taking place? Because these hackers, these cyber criminals want your data. And your data is important. Why? One is your corporate data. One is also the data that you deal, handle, or process in your capacity as an intermediary, as a service provider. It's a third-party data. And that becomes one of the most crucial bits of data which gets sold for much higher premium across both the superficial net as also on the dark net. So these cyber attacks are constantly happening. And if they are happening, please be prepared that this could be also targeting you. There are only two kinds of companies in the world. One who know that they have been hacked, and the other who do not know that they have been hacked. And you could potentially be going ahead and becoming a victim of a cybersecurity breach or of a data breach per se. Now, as of now, India doesn't have a dedicated law on data protection. The Personal Data Protection Bill is currently back to the Indian government after the report of the Joint Parliamentary Committee. So as of now, it's only one legislation which is impacting you, which is the Indian Information Technology Act 2000. Now, you could say that I'm a company, I don't deal with the IT sector. Why do I need to comply with the IT Act and rules and regulations? The reason for this is India's mother legislation pertaining to everything and anything digital. So this has been with us for the last 22 years. We amended it once in 2008 and made a number of changes, including elements that have an impact upon data protection. So you have to quickly start realizing that if you are in India as a company and you're dealing with use of computers, computer systems, computer networks, computer resources, communication devices, as also data and information in the electronic form, your activities are going to be governed by the Information Technology Act 2000. This is a special law, and the provisions of the same prevail over anything inconsistent therewith contained in any other law for the time being in force. Now, 2011, we saw a couple of these rules called the Information Technology Rules. From a data protection standpoint,
two rules really stand out. One is the Information Technology Intermediary Guidelines Rules 2011, and the other one was the Information Technology Reasonable Security Practices and Procedures and Sensitive Personal Data or Information Rules 2011. They effectively laid down the foundation for providing legal framework for protection of data in the Indian context. Now, the ITI SPDI rules became very, very important because they now mandated you to have reasonable security practices and procedures when you are handling or processing sensitive personal data. Let me pause. You are a company. You deal with the data of your customers, your employees, your business partners, business associates, potential business prospects. All the data does not belong to you. You may be collating it. You may be making your own databases, but ultimately this data belongs to someone else. And this data you would be handling or processing in your capacity, either as an intermediary or as a service provider. Having so, you have to realize that the IT Rules 2011 did stipulate various parameters. One of the first parameters was they want you to understand that if you're dealing with sensitive personal data, you will have to have in place compliance with Rule 8 of the Information Technology Reasonable Security Practices and Procedures and Sensitive Personal Data or Information Rules. So a reasonable security practice in a layman's language means an ISO 27001. That company has to be certified as ISO 27001. The answer is a crystal clear no. The law does not want you to be certified, but the law wants you to comply with the parameters of ISO 27001. As companies, let's realize that you are intermediaries. You are network service providers. And therefore, you are in any case covered under Section 2(1)W of the Indian Information Technology Act 2000. And the moment you are intermediary, you are dealing with third-party data. This particular law is effectively giving you a Suraksha Kavach. Remember in the Mahabharata, during the Gita discourse, Lord Krishna has one central message for Arjun. And the message is, Arjun, come within my Sharana and I will protect you. The Indian IT Act has the same message. Section 79 says to all intermediaries that if you comply with the IT Act, exercise due diligence while you discharge your obligations and do not conspire or abet in the commission of any offense, then you come within my ambit. I give you a statutory exemption from legal liability, which means you can be sued, but you cannot be forced to pay 1 rupee damages by way of compensation. You cannot be sent to jail. Now, this is the statutory hallowed exemption from legal liability that all companies must really strive for. Now, you will say that, look, I'm not a service provider. I'm a normal company. I have my own running business. I'm not a vending company like an Airtel or a Vodafone or any other service provider. The law says the moment you are providing any service on the network, you become a network service provider and hence an intermediary. For example, even if you run a company where you provide email connectivity to your employees, you provide mobile connectivity to your employees, you just give an email account to your employees, you save their details, including the financial details, on your database, or you have their health-related records, then quickly you become an intermediary, whether you like it or not. And that's what in which particular manner this new law is going to develop. Till such time, it does not come across. I think, as Dr. Patnaik rightly pointed out, you will have to start inculcating a culture of compliance, a culture of adopting cybersecurity as a way of life, and a culture of focusing on proactive compliances. And mind you, 25th February 2021, the government of India has already now implemented a new set of rules known as the Information Technology Intermediary Guidelines and Digital Storage Ethics Rules 2021. Now, these rules have superseded the Information Technology Intermediary Guidelines Rules 2011. And they have now provided a new landscape that you as companies need to be prepared for. Well, look at all companies, and they're now beginning to start getting compliant with these parameters of IT rules. So don't think you need to be a Facebook, an Instagram, or a Twitter to comply with these IT rules. If you are a company that's dealing with third-party data, you become an intermediary and you comply with these rules. Let's get some things very, very clear. These new rules have mandated that if you are facing or witnessing a cybersecurity breach in your system pertaining to a data breach, then you have no choices but to mandatorily report this to the Indian Nodal Agency on Cybersecurity, being the Indian Computer Emergency Response Team. You don't report it, it actually becomes a crime, punishable with imprisonment and fine. And already, if I look at it, right from the notification of 4th of January 2017 of the Computer Emergency Response Team over to the IT Rules 2021, the law is consistently getting strengthened and evolved. And therefore, it's now absolutely mandatory for you to report any and every cybersecurity breach. Don't think you can put it under the carpet. You try putting it under the carpet and you will have a Damocles sword hanging on your head for the next 7 years, because that's a time frame under which action can be taken against you for not complying with this mandatory requirements of reporting cybersecurity breach. Of course, for that you have to give a proper detailed petition to Computer Emergency Response Team. You also have to file a technical detailed collaborative reporting mechanisms and information to certain. Further, you are a company who deals with third-party data. Please realize the law now mandates you to exercise due diligence while you discharge your obligations under the law. And these various parameters of due diligence have been given under the IT Act, various provisions made thereunder, including the IT Rules 2021. Further, if you are a company and you are an intermediary, the law wants you to inform at least once in a year all your users about your rules and regulations, privacy policy or user agreement, or any changes in the said rules and regulations, privacy policy or user agreement. Further, one
can you
kind of content.
Can you just switch off your video? I think so it will be better.
Sure, just a minute, please. I think with switching off the video, things might be better. So just to make sure that the law now mandates you to follow practices and procedures. Further, once you get an order from the government that provide me some information, you are now duty bound to provide this information to the government. You don't provide information, no problem. Be prepared for legal consequences. Further, you have been mandated, you shall not knowingly deploy or install or modify any configuration of a computer resource or become party to any act that may change or have the potential of changing the normal course of operation of the computer resource. Further, any cybersecurity breaches and Indian Certain becomes your nodal point of contact. Further, if you are an intermediary, please have in place a grievance redressal mechanism, because this has now become mandatory. Any person, user who has a grievance could potentially come and ask for the redressal of the grievances. It's now your duty, you must acknowledge your grievance within first 24 hours. It's your duty that you must now address and dispose of such complaint or grievance within a period of 15 days from the date of receipt. What happens if you don't do that? Rule 7 of the IT Rules 2021 says, if you do not comply with the parameters of the IT Rules 2021, then two consequences happen. Number one, the statutory exemption given to you as an intermediary is automatically standing withdrawn by virtue of operation of the law. And more so, you and your top management become liable for being punished for various offenses under the IT Act and the Indian Penal Code. So these are two twin kind of legal exposures that you have to be prepared for. This is the law of the land as we talk today. As and when a new data protection law comes in, we will have to ensure compliance with that parameters as well. But well, some portions of the IT rules have been challenged. Some portions, for example, Rule 9 has been stayed by the Bombay High Court, but the parameters of the IT rules to the extent that it impacts data protection of 2021, have not been stayed or set aside by any court as of now. Therefore, you will have no choices but to mandatorily comply with those parameters. Further, the PDP bill represents a new, shall I say, threshold in the evolution of the legal frameworks on data protection. It all begins with the Justice B.N. Sri Krishna Committee report. It begins with the journey from the proposed Data Protection Bill 2018. But then the 2019 bill is substantially different from Justice Sri Krishna's draft legislation. But when you look at this particular legislation, you find it's covering a variety and big gamut of various activities, including requirements impacting personal data, restrictive conditions for transfer of data, then even de-identification of data and creation of a data protection authority. Now, we already talked about these issues, about huge powers given to the government, the powers to exempt, and that have really created a huge amount of controversy. There are a lot of dissent notes which have been appended along with the JPC report. But when I look at this concept of data fiduciary, it actually brings across a completely new paradigm. And this paradigm is because if this is the way it's potentially being defined, then somewhere down the line, there's going to be a duality. A company is going to be both a data fiduciary, a company is also likely to be a data intermediary. And therefore, it's likely to be coming up for various compliances, both under the IT Act and also under the new data protection law. When I look at the definition of personal data in the way given under the PDP Bill 2019, very broad, and I think very futuristic, so that any kind of data that tomorrow becomes personal data could also be so brought within the ambit of personal data. Further, sensitive personal data for the first time has been exhaustively defined under the PDP bill. So whether it's financial data, official identifiers, sex life, sexual orientation, biometric data, gender data, transgender status, intersex status, caste or tribe, religious or political belief of affiliation, or any other category defined as sensitive personal data becomes personal data. Nutshell, for a new set of compliances, whatever this new law comes up, primarily because this new law is going to come up with requirement for you on how you're going to deal with not just sensitive personal data, but also with processing of non-personal data, and also issues pertaining to data localization. Now, of course, if you're only talking about processing of anonymized data, the PDP bill does not really apply there. We'll have to wait and watch how the new potential bill is likely to be coming forward. Further, huge powers that's going to be given the PDP bill to the government to exempt any agency from the applicability of the provisions of the PDP bill is indeed very, very controversial and has generated immense discussion and debate. But please realize, if you're a company, you're likely to have various obligations on with respect to collection and processing of personal data. There'll be a purpose limitation and collection limitation on how the data can be collected for what purpose. Further, you will have various obligations in terms of obligations on data processors with whom the data fiduciary may have shared the personal data for fulfillment of the purpose. Notice will have to be given. Why? Because you can't take any data without giving notice. Further, data quality will also be appropriately addressed by you as a company as you go forward. Data requirement will have to be mandatorily addressed by you as a company as you go forward. Consent will be the foundational pillar of the new law, because without consent, you will henceforth not be able to take access to data and proceed forward. Further, if consent is withdrawn, then you will be playing with risk if you're going forward and dealing with such data. Further, there's non-consensual grounds on which data can be processed. The right to confirmation and access will be important right as you go forward. The right of correction and erasure given to data stakeholders will be important and crucial element to be followed by stakeholders. And right of data portability. I, as a user, will have the right to port my data from your status as a service provider to another status. And finally, there'll be right to be forgotten, which will be so important from the perspective of all stakeholders. I think I'm going to stop here because the clock is ticking, but we'll be happy to take any specific questions. It's a very, very big subject, and we as companies are facing immense problems. We'll be happy to discuss about it and see how we can come up with more proactive strategies. Net, the reality is you are a company, you're already dealing with data, you're already going out in the rain. Our advice, please carry an umbrella, carry and wear a good rain suit or a raincoat. Why? Because we don't want you to be wet. Because once you're going to be wet, it's going to open up a new Pandora's box of legal liability to you as an organization, both in terms of civil liability and criminal liability. That's all from my side. Over to you, Pavan. Thanks.
Thank you, Pavan. Very nicely covered, and the advice to the corporate world, which is the need of the hour because they have to implement. And then corporate, everybody covers, whether it's startup, whether it's a big company, a small company, everybody will cover. Thank you very much. We'll take up now time to Ravi. Ravi, what is your view related to corporate? Then we'll do question answer. Only thing is we have to be very brief, okay?
Yes, sir, certainly. I mean, I must concede that I'm a toddler, although a budding lawyer in securities, but a toddler, certainly a toddler here. So it's above my paycheck to give any advice to the corporates, but what I can embark upon certainly is the constitutional background of this entire concept of privacy and how it took a leap from there to this new PDP bill, or which as Dr. Patnaik called it, it's now DP bill. It was first in 1954 in MP Sharma's case when the Supreme Court said that privacy is not protected by Constitution. Later on in Khadak Singh as well, they upheld the same view. Although there were case laws, body of case laws that developed thereafter, which said that no, privacy should be recognized, but the status of law was unclear because, and probably it was in negative because Supreme Court had already decided through MP Sharma and Khadak Singh that the privacy is not protected by Constitution. Later on in 2015, when the Aadhaar case came up, and a detailed exposition has been given by Dr. Duggal and Dr. Patnaik as well. But later on, when Aadhaar case came up, government offered it as a prop before the court. Let us legislate on this aspect. The court should not declare it as a right, fundamental right. Later in Puttaswamy, 2017, the 9-bench, because MP Sharma was a 8-bench judgment of 1954. They had to constitute a 9-bench, 9-judges bench in K. Puttaswamy's case to decide on this aspect. They upheld that the right to privacy is indeed protected by Constitution, Part 3, Chapter of Fundamental Rights. Now, there are 3 facets of privacy. In the words of Gary Bostwick, the conceptual understanding of privacy can be classified into 3: repose, sanctuary, and intimate decision. Repose showcases the freedom from unwarranted stimuli. Sanctuary is the protection from intrusive observation. And third, the intimate decision, that's the third pillar for the conceptual understanding, is the autonomy to make personal life decisions. Now, Dr. Duggal has already given an exposition how the rules are already there and have been there, and what is being done in this PDP is perhaps a consolidation or going into another different level of legislative exercise. And I personally feel, and it is also echoing debate in the galleries, that legislative exercise in this area of data protection, preservation, and information security itself is going to be the exercise, the majority of the exercise which the legislatures will be doing across the world. Now, sir, as far as the corporates are concerned, let us consider one example. We have seen on the individual level, a data breach might have minor consequence. Maybe it can be muddled to a minor consequence or effect. But let us see, assuming from a corporate house, data gets leaked. If the data is price sensitive, it might be known as insider trading. It gets tainted as insider trading, and it has wide-reaching impact. It also hampers the trust and confidence of investors in the securities market itself. So you just see by this analogical example how data breaches, how the leak of data, how the unprivileged access of data with few, and how this asymmetry of power relating to data can have wide-reaching and far-reaching consequences. So therefore, this new bill, although we'll have to see and wait and watch and see how the situation pans out. What do we have in terms of a legislative final act? But the discussion certainly is going in the right direction. The debate is, the quality of debate is really interesting to see. And I'm a reader. I've been reading this data protection law. And I've been seeing the quality of debate that has come up. Now, certainly it is going to be a additional burden of compliance on corporates, but I think it's worth its medal. It's worth it because it will largely decide the kind of civility, the kind of socio-economic development, the kind of change we want in India. The data can be utilized for constructive purposes and as well as for destructive purposes. It has been used shown in the presentation by Dr. Duggal as well. So therefore, I feel that the corporates should be braced up, and wider participation from the corporates would also be required to make a cohesive and so that institutional coherence of this law and the regulatory framework can also be established in India.
Okay, Ravi, thank you very much for giving this. We have few questions with us because this subject is new, so people want to understand this. Before starting our questions which we have received, I have to announce a pleasant information that corporate profession and Pavan Duggal and Associates they are joining hands, and we will work as a strategic partner. So CP announces launch of Cyberlaw practice in partnership with Dr. Pavan Duggal, and corporate professional and Pavan Duggal Associate will work on this, and we will work on each other's strength, and we will move on this. So whatever things are happening in the cyber law, we have our corporate client, which Pavan Duggal can be our strategic partner, and as a partner he can advise to our client, and we can develop a new practice in this area with the law as well as the practitioner side, and we will do something great in this area. Congratulations, Pavan, for this. Thank you. Okay, so now
congratulations to you. Yeah. Congratulations to you. This is a fantastic move, and I really look forward. This will be a great win-win from the perspective of bringing our respective strengths and our expertise for the benefit of our clients. Thank you.
So, Pavan, first question: how the companies, the employer, can handle the situation where employee comes with a request to erase or to forgotten his or her personal data, including sensitive data, considering the fact that employer has to keep data and record as per the various labor law requirements, including for ongoing or future litigation?
Thank you for that question. First and foremost, as of today, the right to be forgotten is not a statutory right as yet, and that too against a private entity. You are a private company. You have to deal and store data of your employee. He may ask for deletion of some bit of his data. To the extent that you think that the deletion can be done, it will be part of good governance and good corporate practices that we delete that. But that does not mean that we are going to mortgage our performance of our statutory obligations. If there is any existing law which requires you to retain such data, then any such request has to be mandatorily denied. Yes, it's a different ballgame altogether that the said user or employee may get a court order. So once you get a court order, then you will have to mandatorily comply, and you can always say that I have done this erasure of or deletion of data as per the orders of the court. And in such a scenario, to that extent, you then cannot be faulted for not complying with applicable laws, because the court of law will only pass such an order after examining your statutory obligations and to find out that there is a golden balance that's going to be met for protecting the rights of the user and also for ensuring that there is no exposure to legal liability for the claim. So as of now, if you get such request, whatever little that you can, please go ahead and do that. But that does not mean that you will not do your normal compliances. Please do the same. Once the data protection bill comes up, we'll have to then wait and watch what will be the specific parameters they would want us to fulfill. Now, once those parameters are legally and properly defined, then as a company, I will have to be ensuring compliance with those parameters. Right now, you can, if there's a request made and you don't want to entertain the request, you can clearly ask your employee or user to get us a court order or an order from a governmental agency. And then you as an intermediary are in any case mandated to comply with all orders of the government or a court of competent jurisdiction under Rule 3 of the IT Rules 2021. And the moment you get such an order from a governmental agency or an order from a court of competent jurisdiction, you can then comply. Otherwise, you can keep such a kind of a request in a pending status. Thanks.
Okay. Pawan, another question is, after the new law is in place, can the government provide do's and don'ts in the form of guidance note or so for corporate to bring certain level of parity in implementation?
There is no denying the fact that the government will have to handhold the corporate sector. Please understand, in India, we don't yet have a culture of proactive compliances. Also, data protection as a jurisprudence has not much evolved in the Indian context. Unlike European Union, where they have a documented history of decades of having in place data protection legal frameworks, you have now to realize that in the Indian context, most of the stakeholders still don't consider data as a valuable entity. Well, if you look at users, the way they are currently dealing with their own data, you don't get a feeling that they actually value data. No wonder so India is seeing the great Indian vomiting revolution, where Indians are vomiting data about their personal, professional, and social lives online without understanding its value or kind of significance. So clearly, I think the onus will be on the government to come up with guidance note stipulating specific do's and don'ts for companies. But please understand, as a company, you cannot wait for that said guidance note to come in. Please comply with the applicable laws as we currently stand today. Why? Because I am in any case exposed to legal consequences as of today. If there's a data breach on my network today, I can get sued for unlimited damages by way of compensation under Section 43A of the Information Technology Act 2000. My top management can be facing criminal prosecution and could actually be booked and even tried for various imprisonment and fine for various offenses under the IT Act and the Indian. Let's go for more proactive compliances and then wait for the governmental practical guidance note in this regard as well. Thanks.
Okay. Ravi, just tell me, you are doing practice in insider trading law and the sensitive price information, unpublished price sensitive information as per SEBI rules, SEBI law. That is already there. So if I say data protection, privacy of law is already there. When this law will come, what is your view on these aspects relating to the frame will be larger and the SEBI can bring out something different? What is your view? Yes,
sir, certainly. I think you're absolutely right when you say that these aspects of privacy of corporate unpublished price sensitive data has already been there, and you see it's in bits. Somewhere these have been legislated upon by the regulator and legislators. This new bill, it's certainly, as Sir has said, Mr. Duggal had said that it's entirely a new gamut. The ambit is so wide and so multi-dimensional that we'll have to wait and watch how things will shape up after the final act comes in. But one thing is clear that the regulators, because Dr. Patnaik also alluded that there will be agreements between the regulators and the DPA about data sharing, how they'll process the data, how they'll store the data. So definitely the enforcement as well as surveillance by SEBI is going to increase. It is going to be benefited by this new law. And therefore the data, and also the concepts of data localization would also ensure that the UPSI, the leakages, particularly in the insider trading area, they're also curbed down. a little. So yes, I feel that there would be an impact on it.
Okay. Pawan, there a very interesting question has come. That is a need of the corporate. He's saying we run a nationwide quiz program, data relating to which is handled by a service provider. Am I responsible for the data protection or my service provider? Do I need to obtain a certificate from my service provider on compliance with the laws or technical compliance?
Definitely. Once you are running this nationwide quiz, it's you as a legal entity, your company that's running it. You are the face of it. So if you are not going to be careful of the data that's being collected vis-a-vis the said nationwide quiz program, then you could be facing legal consequences. If I'm participating in other places which it ought not to be, the only entity whom I will be suing will be your company. So you will definitely be liable because you are the organizer of the said quiz competition.
Okay.
Hence, it will be much better that since you are already outsourcing that to the service provider, you must get the appropriate certifications and indemnity bonds from the service provider. You must give their undertakings that they are complying with the parameters of the IT Act and rules and regulations. And they will also indemnify you in the event there is any such claim. That's one. In addition, you must also, as a legal entity, be seen to tomorrow want to be potentially having a very good quality exit from legal liability, because it will be great for you as a company if you can take the benefit of the statutory exemption from legal liability.
Okay. Will professional chartered accountant
people can sue you, but so long as you can't.
Okay. Mr. Pawan, will chartered accountant company secretary will be covered under the definition of DPO as suggested by JPC? Pawan, I think your connection is losing. Pawan, are you able to hear me?
Yes, I can hear you, please. Can you hear me?
Will company secretary and chartered account will be covered under the definition of DPO as suggested by JPC?
We hope so. The reason for this is the JPC has strongly recommended this, and it makes logical sense. You see, country really wants to utilize the best potential that it has. And since all these professionals are already available, they can be fantastic resources as becoming as DPOs. But we'll have to still wait and watch what is the final language of the new law that the government is going to come across. If the government accepts this particular recommendation of JPC, I think it's going to go tremendously forward in terms of not just enriching the professions and the professionals, but also in giving a great service to the cause of protection of data in the Indian context. Thanks.
Okay. If an NGO collects data for distribution of blankets, so that NGO will be covered under the law?
Absolutely. Your dealing with data with money has got no connection. The moment you are handling or processing data, whether it's for money or whether it's without money, whether you are a normal corporate, whether you are not for profit, whether you are an NGO, you will still be covered under the new law, and you are in any case covered under the Information Technology Act 2000. And as and when there is some kind of a legal issue, you will be asked to call to show how you have complied with the relevant parameters of applicable law. Thanks.
Pawan, you have seen that there are so many sites when you registered yourself, they are asking your email address, and then they are asking whether you want to register through Facebook, through Gmail, through other source. And when you are going for Gmail, they are asking your password of Gmail. Now the question is, my email password, which I'm not sharing with anybody in the organization in any place, because he can track my email. How these people are asking whether we should register with these people or not. There are so many reputed sites also doing this. What is your advice?
See, my advice is please understand this is all based on the API ecosystem and the parameters, and logically we are all working in a collaborative economy. So long as you are authenticating yourself through your service provider, please make sure that you have read the terms and conditions of both the service provider and also the platform where you're registering yourself, and see specifically in their privacy policy how the said data of yours is going to be shared, transmitted, or otherwise made available. If you are comfortable with doing that, you can go ahead and sign via these service providers. But it's always a good idea that it will take a bit more longer time, a slightly more inconvenient approach, but it'll be good idea if you can do independent registrations. Why? Because you have more control over your data. I'm simply going to give access or permissions to all kinds of platforms to access all kinds of information. Tomorrow, you will have no clue on how your personal data is potentially going to be dealt, handled, or processed. We've seen so many rogue mobile applications, rogue websites, rogue platforms who have actually emerged, who've gone ahead and misused this particular process. Hence, it's always better that we err on the side of caution to the best extent possible, unless until you are really reliant and you are really confident about the platforms that you are potentially going to be authenticating by means of your other social media accounts. It's preferable to do each independent exercise as an independent standalone act. Thanks.
Okay, today I was reading the India Today. They came out that who is using your Gmail account, you will be shocked to know. And they are saying that your Gmail account is connected with other accounts, other platform, other things. So what is this concept and why this is coming?
Well, you have to understand that Google knows far more about you than your family members and your friends, your family, your wife, your husband, or your parents. This is so because of the huge digital dust that we are leaving behind. These are the electronic footprints. And since a majority of these service providers provide you so much of world-class information or services for free, most of the time, people want to go ahead and sign these kinds of services for their convenience. But the moment you start sharing, or the moment the platform starts sharing your data with large number of entities, as it mandatorily discloses in its privacy policy, you suddenly begin to start realizing how your data is being shared across all levels. Therefore, as we go forward, while there will still be need for free email accounts with 15 GB data or 30 GB data, 1 TB data, more and more as people become more conscious about the significance and relevance of the data, there'll be increased migration of users towards those services, those platforms who tend to give far more premium on protecting the privacy of users. For any simple, just to give an example, a lot of people today use WhatsApp. But when you consider privacy of WhatsApp, you're already sharing your entire information with Facebook group of companies, and under the new proposed amended privacy policy, with all its business associates, vendors across the world, even with those vendors with whom you may have never got any kind of a privity of one exercise. On the other hand, you see a platform like Signal, who specifically tells you that your data is yours and they're not going to share it. When Signal was asked to share their customer data with the government agencies in one continent, they refused to do so because they said, look, protecting the privacy of our users is of paramount necessity. So I think as a user, let's be picky enough to choose which particular platform we want to do. And our choice of pick will be dependent on how our privacy is being dealt, handled, or given appropriate respect to by the relevant service provider or platform. Thanks.
One last question. Recently, you remember, you may recall that American parliamentarian called Sundar Pichai, the Google head. And they asked this question: more than 90% of all internet searches take place on Google or its subsidiaries. YouTube, they are cutting what we see on Google, has long faced criticism for manipulating search results to censor conservatives. Conservatives, individual and organization have led their pro-Trump content tagged as hate speech or had their content reduced in search results. What is your view on this, that Google has everything? They know what is your liking. And I am seeing that if I like some certain things, and then same type of thing will come to me. So I will not have a balanced view. Yeah, suppose I like Modi, so Modi things will come. If I hate Modi, then hate Modi will things come. So I can't have a balanced view. What is your view?
See, you will have to make your own choices how balanced view you want to evolve. If you would want your service provider to color your vision, it's becoming so very easy. Because today is the information age. We are in the data economy where fake news is all around us. The current pandemic is not just an cyber pandemic, but also is an infodemic, where all kinds of false information are floating all around us. And therefore, people have to be sensitized on how they can potentially be made more capacity built in terms of identifying what is fake news versus what's not. I think somewhere down the line, let's begin by not trusting what we are seeing. Let's begin to start inculcating a culture of distrust and mistrust, and only rely upon information once you have independently corroborated its authenticity or veracity. Otherwise, it's in the business and the commercial interests of companies like Google to go ahead and only feed you that particular kind of information that you would want to see. And logically, so it makes sense. You would only want to listen to the kind of music you like. And once they know what music you like, and once that kind of music gets bombarded onto you, the chances of you getting habituated to that kind of content is going to be far more higher. And that effectively is going to be helping enhance the commercial interests and the business interests of companies like Google. So I think as these big tech companies are evolving, they are becoming big data repositories and huge powerhouses who are out to influence thought processes of individuals, companies, organizations, and even elections and countries at large. I think we require a new orientation. A lot of people believe that our privacy has been already lost, but whatever limited remains, it's our job to try to retain and regain back that particular privacy. We must start a culture of not just becoming more cyber resilient, but also adopting due diligence and trying to question what we are seeing. Let's not be ourselves be influenced by the kind of content the service provider is dishing onto us, but that will require more capacity building. And for that, a lot of effort has to be done by stakeholders, by the governments, by the corporate sector, and by the academia as well. In fact, we have created a platform called cyberlawuniversity.com, where we offer all courses on the aspects of cyber law, cybercrime, and cybersecurity to enhance the knowledge and the skill levels of stakeholders in this regard. Thanks.
Thank you, Pawan. Thank you very much. I have received last question, but I can give answer. The power of data protection officer will be so wide that it shall be misused. How to deal with that? Everywhere it is happening that these data protection officer has to follow the code of conduct, and the government will come out with the rules. And this is obvious that anybody who is assigned to certain power, they have to follow this. So that will come, and this is a law which will evolve. So thank you very much, Pawan. Thank you very much, Mr. Amar Patnaik in absence, and Mr. Maheshwari and Ravi, those who have given the dimension of Data Protection Act and the new things which is coming. And everybody is in India using mobile phone. Everybody is using in India. Everybody, when I'm saying majority people, they have email account. So anybody who has mobile, who has email account, it means that his data should be protected. So in a way, entire country covers in this. Under the process of this data management and data using, and then going for various sites, various downloading apps, various cyber issues we are managing, we are bound to, people will take advantage of this. I hope that this law will emerge. This law is evolving, but everybody should realize that your information is important. Secrecy of information and privacy of information is a big difference which we have to understand. And we should know what is my right and what is my duty also. In this case, duty of corporate is there, but as an individual, your duty is to protect yourself. And right is that if somebody is misutilizing your right, how to protect this, how to take action on this. You must know, and that is the important thing that can be learned by participating, understanding, and using this. Somebody may say cyber law is a Pavan Duggal subject. No. Now this is a subject of each individual who should know what is do's and don'ts. And shortly we will come out with Pavan Duggal. We will organize one program, the do's and don'ts for the user of this cyber law, this data, this information, website, the account, email, Gmail, so many things. So we will come out and we will tell how to protect yourself, how this cyber protection will help you to protect you in future to becoming a product. Because today you are getting everything free, so you think that I can use it. No, nothing is free, because in the free world, you are not getting free, but you are the product. So people are using it as a product. So thank you very much to all participants, all my four dignitaries and expert on this. And my congratulations to Pawan that we will start this new journey in a different way. And our knowledge relating to the compliance part, your litigation part, and then the other subject part, which is a part and parcel of like SEBI law is very, very important, insider trading, which is only on the basis of data, information. So that we will jointly work out something great for the corporate world, and we'll do. Friends, my special thanks to all participants, those who have come in this program. And continuing to our journey, our next program, or 78th program, will be held on the labor law, because preparation of labor code is there now, and the 1st April is the date when the things will start. In labor code, you have to understand the implication of the financial, you have to understand the implication and the structuring which you have to make for your corporate, your office or your company. That is a need of the hour. So next program is labor code, how you have prepared yourself. That will be our, and Mr. Anupam Malik, who is the additional commissioner, ex-additional commissioner of labor law, Haryana, and Mr. And some other dignitaries will participate in this. Thank you very much. Thank you all for participating. Thank you.